of CMR University School of Legal Studies, I would like to extend a warm welcome to our speaker for today, Mr. Mohan B. Sir, Senior Advocate, Supreme Court of India, for today's webinar on the topic, the rule of law in international law. Before we begin, I would like to request all the members of the audience and the faculty to please keep your videos turned off and your mics muted for the duration of the webinar. If you have any questions or queries, you can place them in the chat box and they will be addressed at a subsequent point. Thank you. Before the session begins, let us have a brief understanding of the subject matter of today's talk, the rule of law in international law. The rule of law is generally understood as a moral idea, which protects the distinctive legal qualities of independence of courts, of the due process of law, and equality before law. The primary objective of the rule of law is the protection of individual freedom and their well-being, to achieve which we may take assistance from the international law. Moreover, simultaneously, the rule of law also helps to promote international peace, security, and to promote political stability, which in turn helps to further social development and economic progress, and thereby helps to protect individual rights and their freedoms. The foundation of the rule of law helps the public to access public systems. It helps to curb corruption and to restrict the abuse of power. This in turn helps to establish an effective social contract between the people and the state. Therefore, the rule of law and development are very strongly interlinked. And to consider the rule of law-based society as an outcome of the 2030 Agenda for Sustainable Development Goals would be a valid reason. Furthermore, to understand how the rule of law can be strengthened, we need to respect the norms of international law, including on the use of violence, which involves a primary understanding that the basic and fundamental responsibility of the state is to protect its populations from various war crimes, crimes against humanity, genocide, ethnic cleansing, etc. The rule of law is therefore foundational to the humanitarian and human rights protection regime. It is crucial to understand and to address the problems of displacement and statelessness, and thus is the foundation of the humanitarian protection regime. On that note, I would now like to invite Priyanka from 5th semester BA LLB to deliver the welcome speech.
A very good afternoon to one and all present here. Respected Dean, Professor T.R. Subramanya, our Vice Principal, Professor Praneshwaran, and all the faculty members and my beloved friends of CMR University School of Legal Studies. I, Priyanka, from 5th semester BA LLB, on behalf of CMR University School of Legal Studies, would like to extend our heartfelt welcome to our respected speaker of the day, Mr. Mohan V. Katarki, who is a senior advocate designated by the Supreme Court of India. Mr. Mohan obtained a bachelor's degree in science and law. He further represented the states of Karnataka, Odisha, Punjab, Kerala, and the National Capital Territory of Delhi in several important transboundary water disputes before the Supreme Court of India and interstate water dispute tribunals. Mr. Mohan V. Katarki is an honorary visiting professor in the University Law College of Bangalore. Being the Vice President of Bar Association of India, New Delhi, a member of the Academic Council of National Law School of India, University Bangalore from 2000 to 2008, a member of the editorial advisory boards of Students' Law Review published by the Karnataka State Law University and Bangalore University Law Journal published by Bangalore University, and a member of Board of Management and Planning, Karnataka State Law University, Hubli. He attended several international conferences, which include biennial conferences on ILA at London in 2000, New Delhi in 2002, Toronto in 2006, Hague in 2010, Washington, D.C. in 2014, and Johannesburg in 2016. Mr. Mohan has delivered lectures at international conferences and seminars. Some of the important papers presented and lectures delivered by him are Equitable Sharing of Transboundary Krishna Waters, Indian Experience, at Teslik, Bosnia in June 2001. Equitable management and allocation of transboundary waters in India at Colorado Law School, Boulder, USA in June 2002. If the climate change is possibility, will there be reallocation of international waters at West Bengal National University of Juridical Sciences at Kolkata in Feb 2012? 20th Law Asia Conference at Sydney on the topic Hydropower Generation, Transboundary Environmental Issues in November 2015. He has published a large number of articles, papers, and blogs, and his contribution to academics has been significant and substantial. It is indeed an honor to have you today, sir. Thank you.
Thank you, Priyanka. I would now like to request Mr. Mohan, sir, to take over the platform and address the topic for today's webinar.
Yeah, thank you. At the outset, may I thank the law school for inviting me as guest lecturer. It is a little odd for me to lecture because the head of the law school, Professor Subramania, had been my professor also. When I studied law at UCL Harvard, he taught me international law. He taught me so well. I still vividly remember his passion for the subject, the way he used to coin the phrases, the way he used to deliver the lecture with emotion. These are all the things which really made me to think, why should I not pay more attention and study the international law? Once I asked him in the question in the class, so what is the use of this international law? Does it have any practical value? He looked at me a little angrily and said, look here, this international law is meant for addressing the issues which are international in character. And in India, he immediately cited an example, that Karnataka government had to consult an international lawyer with regard to the Kaveri water dispute. So when I became a lawyer for the state of Karnataka in the year 1990, and immediately my inquiry was, who is that international lawyer who was helping the state of Karnataka in Kaveri? Then I learned through my senior colleagues who had been associated earlier that it is great Professor Lipper, who was a professor of international law at the University of New York. But the subject on which he was consulted was not Kaveri, it was Krishna water dispute. So this is how I got into the subject of international law, being a counsel for the state of Karnataka and several states dealing with international water law and other subjects. Besides, I really think international law is a law built on the municipal law, because as many of the authors have said, the principles have been developed by way of analogy to fit to the international interactions. Whatever. The topic for today is an interesting topic: rule of law in international law. Rule of law in international law. International law, as you all know, starts with one principle, and perhaps that still remains the most important principle. That is, the states are sovereign. The duty of international law is, or the purpose of international law is, to regulate the intercourse between the states with regard to various aspects they encounter in their international affairs. Keeping the state sovereignty intact, the international legal order has been worked out. However, as the industrialization started, the international commerce and trade became important. The international law had to step in to expand its wings beyond saying that states are sovereign. So doctrine of state responsibility and others crept in. Since then, we have seen international law is not only a law which protects the state sovereignty, it has gone ahead and regulated various aspects between the two sovereign states. These relate to the relation between a sovereign state with an individual, two individuals again. One is a foreigner, how to deal a foreign national. Secondly, the relationship with its own nationals, which is important, particularly in these days with the growth of human rights. Next is the relationship between the sovereign state and the environment. Treating environment as nobody's property, but all other common responsibility to protect it. The international law has imposed certain obligations on the states. Then comes regulation of trade. As I said, post-industrialization demanded trading of the goods in a larger scale. Therefore, the trade could not be only left to the merchants from Europe to merchants in India or anywhere in Asia. The international law had to step in to regulate the trade. Today, we have reached a stage where there is a separate and a solid branch of law called international trade law, and an institution of WTO is there. Next is, we have international law dealing with a relationship between the two states with regard to the common resources like water or sea. Then we have, which is very important in the present context of pandemic, that what is the responsibility of the state towards the injury caused by neighboring state, either deliberately or negligently. So all these things are the subject of international law, but these aspects or these areas, international law has not been able to play an effective role because still international law is sovereign-centric. It doesn't want to do anything which is seen as cutting into the sovereignty of the states beyond really necessary. You do not have an international legislature to legislate. So international law is basically a law made by the states out of contract or treaty. It is only if the dispute is submitted to an international body, whether ICJ or any of the arbitration, the courts or adjudicator has some larger freedom to apply the international law beyond the treaties by looking into the other sources, provided the relationship is not fully covered by the treaties. Therefore, the heart of international law is rested on the consent of the states. Without consent, nothing can be imposed in international law. Therefore, I said the first principle of international law, perhaps the last principle, is that states are sovereign and nothing can be done against their will. So this is how the international law has grown around, and this is how the international law has played its role. Many players in the international relationship do not take international law seriously. Most of the international commentators, most of the speakers on international affairs hardly speak in the language which is consistent with international law. This is because still the experts in international relations or foreign affairs, whatever you call them, think that international relationship is nothing but a power game in which everything is fair as long as it serves your interest. So no policies, no plans are really made having regard to the international legalism or international obligations. This is unfortunate, but this is how the world has been carrying on. However, in the last a decade or more, as the globalization picked up, as the international trade became important, as the people started moving from one state to another, questions are frequently asked, why can't there be international regulation to fix certain important aspects of the trade, particularly the finance? The 2008 crisis, the recession caused in America, which had an impact elsewhere in the world, almost crippling the world economy, forced international experts to concede that the regulation of economic aspects at the state level is necessary. Therefore, the international treaties started flowing out in the form of memorandum of understandings or whatever they call, trying to regulate the movement of international finance. Still, international finance is mainly governed by private international law, but you also see many international regulations which are in the field of public international law. For example, the investment treaty is not a part of private international law. It's a part of public international law, because it was thought that if a citizen of a nation goes and makes investment in another nation, he needs a protection. So the nations started entering into the investment treaties to protect the investment of their nationals in another country. This is how the international law, public international law, has been expanding its area. But with this expansion comes a requirement, a demand, a cry that the international law should be fair. It should be just and fair. It should be tested on the touchstone of just and fair, as we usually test with regard to the domestic legislations. So this is how the great moral principle of rule of law is coming into picture. The international law as rule by law is being challenged, and international law as rule of law is being increasingly promoted, but still it is at a level which is not visible. It is mainly in interpreting the rules and regulations. The regard is given to the principles of reasonableness, or what is just and fair, or a due process. But at a larger level, if the international law has to kiss rule of law, it has to embrace rule of law, then there has to be greater structural changes which are necessary. The structural changes are necessary at the highest because you all know the rule of law means supremacy of the law. It accidentally came up through Magna Carta in 13th century. Thereafter, the English jurist Dicey equated rule of law to the ordinary court where everyone is accountable, including the government. So the rule of law has undergone changes, has undergone various interpretation, and now it is largely understood as the principle of law which promotes, which prescribes rather, the due process, separation of power, supremacy of the law, equality. So these are the important things. And these principles are indeed incorporated in the constitution of most of the states, with the most important additional point, that is independent judiciary to enforce the legality or the rights of the individuals against the government. So the rule of law, what we understand in the domestic sense, is a moral principle which has been now crystallized into the constitutions of various nations. And beyond that, we really do not look what is rule of law. If you ask me what is the rule of law in India, that means it is all crystallized and collapsed into the Constitution of India. That is rule of law. But that's not the case with international community, because there is nothing as such an international legislation or legislative body to make a law or international constitution which crystallizes the rule of law. Therefore, we'll have to see and try to read the rule of law in various branches of international law. You all know that after the Second World War, the both powers which won the war and which lost the war sat together and decided to work out peace for the world. In the process, the foremost thing they did was to erect an international institution superseding the old institution, League of Nations. The United Nations has been created. Now, in the last 70 years, the United Nations is the sort of international administrative body or a quasi-legislative body. It has no power to make law. It has some executive powers. And through the Security Council, which is controlled by only few of the members, which is not democratic, acts. So the first thing rule of law has to recognize is to reform the United Nations. With regard to the General Assembly of the United Nations, fortunately, there is already a rule of law. In a sense, all members are equal, all have one single transferable vote on any issue. It may be United Nations, it may be small island Haiti or Bahamas next to United Nations, both have one single transferable vote. Therefore, to that extent, the UN General Assembly represents and promotes principle of formal equality. But when it comes to the Security Council, it's not so. The executive power of the United Nations, which is vested in the Security Council, and Security Council is seen as a body or institution to enforce the international law by prescribing the punishment against the violators or punishing the culprits. Now, what is this Security Council? It is essentially controlled by 5 permanent members. These permanent members are permanent. You cannot remove them. Therefore, the element of democracy, the element of equality of state, which is the most important aspect of the rule of law, does not exist as far as the functioning or the structure of Security Council is concerned. Therefore, the foremost reform in the implementation of rule of law that is required is abolition of permanent membership of 5 nations, or at least expanding it to the members more than 5 based upon some objective criteria. That's the only way a democratization and accountability can be introduced in the Security Council. Second important aspect is if a Security Council takes a decision against a particular nation, what is the remedy? Today, there is no remedy. You will have to submit to the Security Council whatever decision it takes. If Security Council decides that the collective intervention is necessary in Bosnia or any of the nations that did it in Libya and Lebanon, then nothing can be done because you will have to abide by the decision of the Security Council. But if Security Council wants, it can take an advisory opinion from International Court of Justice. In the views of almost everyone who is a teacher in international law, the Security Council should be held accountable before the International Court of Justice. Therefore, a compulsory jurisdiction has to be created in the International Court of Justice. An International Court of Justice should have the powers to review the decisions of the Security Council as a supervisory judicial body, as the national courts act and exercise supervisory jurisdiction in the form of issuance of writ of mandamus, writ of prohibition, writ of certiorari, so and so. Like that, the International Court of Justice should be vested with powers to have a supervisory jurisdiction over the decisions of the Security Council. This will go a long way in democratizing the Security Council and making it accountable to the rule of law. This will help in upholding the rule of law. This will help in saying rule of law is supreme. We should, in an ideal sense, have an international parliament. That means General Assembly should be given a power to legislate. But I'm not sure that is possible in the present political circumstances. But at least the democratization and introduction of accountability in the Security Council is very essential to inject sense of rule of law in international legal system. Besides this, the international law has to make itself available to enforce the series of human rights conventions it has enacted. The General Assembly has been very active in the last 70 years with regard to the codification and crystallization of international law on human rights. It has played a great stellar role. But these human rights cannot be enforced against the international body. You cannot go to Security Council and say that my government is not respecting my right to speech, or it is not treating me equally, whatever. You will have to go to your own national government. This remedy in many of the countries, in developing countries, is not being seen as adequate. Even in the developed countries, we have seen recently how a ruler of a state, an elected person, can become arbitrary and create difficulties to his own citizens. Therefore, some sort of a check at the international level is necessary. An international tribunal or international judicial system is to be established where, in certain circumstances, the body is able to hear a complaint of violation of fundamental rights or human rights by the state. So this is another thing which goes a long way and which helps in giving an image of rule of law to the international law. The next is, one second, humanitarian intervention. It's a very complex subject. We all know, and we said, discussed, that states are sovereign, and how I deal with my people is my concern. As long as I'm able to guarantee certain basic human rights which international community prescribes, I'm not accountable beyond that. This is the attitude of the states. We also seen how the rulers of the state treated, tortured, maimed, killed their own citizens because of ethnic war or several reasons. The minorities are subjected to torture, or sometimes based upon the color, the torture is inflicted. For various reasons, it happens. There is no really a set reason or typical things. In these kind of situations, the international community owes a responsibility to intervene and save the people. So this intervention or humanitarian intervention has been the part of customary rule of international law for long, no doubt about it. Right from the year 1824, when Britain, France, Russia decided to protect the Christian minorities in Ottoman Empire, particularly in Greece, which is considered always by the Western powers as their mother. The humanitarian intervention was declared and successfully executed. We have seen in the recent last 30 years, couple of humanitarian interventions have been done. NATO did it in 1990 in Yugoslavia to protect the minority population. But humanitarian intervention has been a subject of critical analysis. There has been strong objections to the humanitarian intervention if it is not conducted by the collective wisdom of the international community. What has been happening is the superpower, United Nations or group of nations, take a decision that we owe an obligation on behalf of the international community to go and protect the citizens, Libya or Lebanon, whatever, and intervene. This sort of intervention by other states or group of states is creating a situation of one-upmanship. Therefore, what has to be done is the humanitarian intervention should be confined only to the intervention by the Security Council. This can happen effectively provided Security Council is able to raise its own armed forces. Today, the biggest problem in the Security Council is it doesn't have its own armed forces. It has to depend upon the superior Western powers to make any humanitarian intervention. Therefore, the Security Council or United Nations must have its own army, which is able to go anywhere in the world for the purpose of restoring the peace and protecting the people. So this is a very important aspect which has to be brought in. The next is strengthening of the International Court of Justice. Strengthening of the International Criminal Court. We have come across a lot of crimes committed by the states against its own people. Genocides have taken place. The rulers who are responsible for this are being subjected to trial by the ad hoc international courts established by the Security Council, or if the nation is a party to the Rome Statute establishing International Criminal Court, then a complaint is lodged. Therefore, this International Criminal Court needs to be strengthened in such a way that all the members of the United Nations should become or should ratify the treaty and subject themselves to the jurisdiction of the International Criminal Court. This is very essential. Apart from this, the International Court of Justice is today, as I already said, has no compulsory jurisdiction. Its jurisdiction is only by consent of the parties. If a dispute arises between India and some other nation, one cannot go and sue before the International Court of Justice. He and both the country, means the India and the country with whom it has raised a dispute, have to agree and submit before the International Court of Justice for adjudication and the judgment. The only other instance when International Court of Justice accepts a complaint is if there is already a treaty and the treaty says in case of any dispute with regard to the implementation of the treaty or interpretation, then the International Court of Justice will have jurisdiction. So the International Court of Justice in the present system of international legal order has no compulsory jurisdiction like a civil courts have in India or elsewhere, where you can go and file a plaint, court will issue a summons. That is not possible. Either you expressly consent to submit to the International Court of Justice, or you are already consented in a treaty or agreement which permits one state that is agreed to file a complaint. This must undergo change. There must be a provision for compulsory jurisdiction. If a compulsory jurisdiction has been vested in the International Court of Justice, there would have been 100 complaints against China for creating the present pandemic situation. The court would have gone into the issue, would have called upon China to explain whether it is the virus is created or it so happened it accidentally got into some human being and before they could take steps, it got spread. So it had to explain its conduct. And if the court feels that China had actually created the virus, or if it had not created, but it failed to take the necessary steps and prevent its spreading, then it can be held responsible. But today we can't do anything of this sort because no court in the world has a compulsory jurisdiction to entertain any complaint against China And it also doesn't help China because there is no forum in the world before whom the China can go and clear its stand that it is not guilty of any sort in spreading the coronavirus. So a compulsory jurisdiction on certain items, particularly the international torts which create injury, I think is very essential. The last item, which requires attention of the international community, which helps in promoting rule of law, is the international currency. Today we are living in this world. There's a huge international trade, interaction, transfer of goods. Millions of people fly from this end to that end every day, but you do not earn international currency. The currency of United States of America is the de facto international currency. That is, the people in the world have been accepting it. They are accepting it because the oil producing nations in 1970 agreed to sell the oil only against dollar. That's how a link between dollar and oil was brought into picture in 1970. And that made the dollar the most important currency or a commodity for exchange around the world. When India buys something from Australia or something from China or Singapore, it pays in a dollar. So for India and China or India or Australia or Singapore, when they transact in dollar, for them, dollar is not a currency actually, it's a commodity. So this has created a lot of imbalance. The reason being, take the oil producing countries or take India, any country. We have to really export something and earn the dollar. Whereas United States of America can merely print the dollar. So this sort of inequality in currency has to be put an end to. I can't sweat. I can't take trouble. I can't earn the dollar. I can't be subjected to these kind of difficulties to earn the dollar. Whereas the United States of America creates dollar by just printing. It has no backup of the gold, nothing as such. It is called a fiat currency, that is a currency printed at will. It's a different matter. If United States of America prints more, it may have to suffer inflation. That is separate, I'm not concerned. But the fact remains that it has the power to create a dollar. The same dollar all other nations have to sweat to earn. So this must come to an end. The international community must set up its own currency, preferably the existing institution, IMF, should be made use of, and it should be invested with the necessary powers by a treaty to print international currency, and the trade must take place in international currency. That's all. That's how the equality between the states can be established. Friends, this is all I can speak as a practicing lawyer to the extent I know the international law. The rest of the things my Professor T.R. Subramaniam will teach you. Thank you very much. And it's a really a great time speaking to you all. Thank you.
Thank you, sir, for that extremely insightful and formidable talk. I would now like to request for your permission to take any questions from the audience.
Sure.
If the audience has any questions, please post them in the chat box. If any of the members of the audience have any questions, please post them in the chat box.
No questions.
So there is a question.
Really?
Kanan asks, how does the international law help in fighting cyber terrorism?
Just clarified how the international law
Help in fighting cyber terrorism.
Well, international law so far doesn't have a structure to fight international cyber terrorism. What happens is it is left to the presently national jurisdiction to create its own system. And hello. 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 There's some disturbance.
Sorry, sir. It's been muted. You can go ahead, sir. Sorry.
Yeah. So presently, the cyber terrorism has to be dealt by the nation at its own level. But this is a subject on which the international community has to pay attention, has to enter into create a treaty and establish an institution to take care of cyber terrorism. Because with the growth of information technology, and particularly the artificial intelligence, the cyber attacks are going to be frequent. And therefore, an international policeman, a cyber policeman is necessary to deal with such things. Thank you.
Thank you, sir. Sir, there is one more question. Akanksha asks, USA has no gold reserves, then what is the basis for printing notes?
Well, after the Second World War in 1949-48, the world took a decision, Bretton Woods Conference it is called, that each nation is free to print the currencies without being backed up by any gold reserve. As a result, the nations, particularly the developing nations, felt liberated and started printing the notes to help boost their economy for development. It really worked very well. It does work in case of disasters. Even now in India, at least 3% of our currencies, 3% of the GDP are printed, or in other words, nearly about 35% of the annual budget comes from the borrowings, which are subsequently monetized and covered up by printing of the currencies. The United Nations in 1970 around, it delinked its dollar from the gold reserve. At present, there is nothing. The currency, or that is the dollar which United States prints, it is a sovereign promise that it will honor. So it is only the might of United Nations. If you have trust, you trade in that. You accept the dollar. Or if you have no trust, end of the matter. So this is a fiat currency. It has no backing. The only internal pressure in the United States government is that if you print more currencies, you might create inflation, which may affect its economy. That's the only pressure on the United States government, or for that matter, any government, including the government of India.
Thank you, sir. Sir, there is one more question.
Sure.
What protection should be taken when a person I'm sorry, could you please rephrase your question? Okay, sir, there's another question.
Sure.
Is the Cold War started between US and China?
It seems so. I'm not sure. See, the Cold War is basically a war between United States of America and USSR after the Second World War, post 1950. What happened was the UN Charter banned war. Previous to the United Nations Charter enactment, a nation had a right to wage a war freely as it likes to redress its grievances. War is considered as a legitimate remedy to redress any of the grievances it has. But after the Second World War, the right to wage war was outlawed, except in self-defense. As a result, in the post-1950, both United States of America and its arch rival, USSR, had to carry on their rivalry without resorting to any war. And as a result, over the years, it became known as a Cold War, that you don't want to really go for war, but you are in a position waiting for other to start and you react for that. Anyway, this phrase of the Cold War has a different meaning. I'm just trying to give my meaning. What's going to happen before China and US is possible, another beginning of the Cold War, but it could be also possible there could be a real war also. One doesn't know. It all depends upon the economic interest of United States of America. At the moment, China has about 4 trillion US dollars. What I said, US prints dollars. China has earned that dollar by hard work, by its sweat. The China is also in US dollar trap, because if it does anything, the US might just react by demonetization of the dollar, right? As India demonetized its currency, US also may demonetize the dollar and say that all the dollars which are held by anyone outside the United States of America will not be honored. So that can take place. But that is a political decision. The consequences of that, the US will have to bear in mind, because the entire world economy will come to a standstill. There'll be chaos. Or it can be limited to the China. It can happen. But that threat is there for the China, that it has been holding the US currency. It also cannot cross certain limits. But at the same time, the United States of America also has concerns against China. There is a lot of trade surplus. So these are the issues for them to address and deal with. I'm not sure how will they do. That depends upon the government. But certainly there will be a tension between the two nations. It may or may not escalate into any armed conflict.
So there are a couple of more questions.
Sure.
Manish asks, sir, why is there no liability imposed by international law on China for the corona pandemic?
The liability is there. A nation is held liable if it is proved that it has caused an injury to other nation. But the problem I said is, in international law or international legal system, there is no compulsory jurisdiction for any court to entertain the complaint. Suppose the International Court of Justice had compulsory jurisdiction, India could have lodged a plaint, US could have lodged a plaint, and called upon China to answer its charges and pay the compensation, could have followed. But that nothing can be done because there's no compulsory jurisdiction. So the substantive law, what we say, that international thought that a nation ought not cause any harm to other nation today is only a paper right, because there is no forum to enforce this. The most we can do is go and lodge a complaint before Security Council. Security Council, as the executive body of the United Nations, may take some action, but again, there is a group of permanent members, and China is one of the permanent members. It will naturally veto any action against itself. So, in this sense, whatever right is there against China, if it is guilty, I'm not saying it is guilty, it is to be proved, it cannot be enforced unless China agrees to submit itself to the International Court of International Arbitration, whatever. Yeah.
Thank you, sir. Sir, the next question is from Manjushri. It is, are there any case studies or cases of international law that, according to you, is of profound importance?
Is there any, just please repeat the question.
Sorry, sir. Are there any case studies or cases of international law that, according to you, is of profound importance?
Okay, there are many are there. As a student, Professor Subramania guided me in one international mood competition. So I extensively studied the Corfu Channel case, and I always considered it as very important for my understanding of the international law as a student. The many case laws, there are many cases, no doubt about it. You can just pick up the recent case of the International Court of Justice. They are all available on the website now. You can see it. You can read the Kulbuch and Jadhav case. You can read any of the cases. You'll be able to follow the development of international law. But there is nothing like one great case. Like in India, we say Keshananda Bharati case or Maneka Gandhi case. These are the important path-breaking decisions. If you read them, you really get the legal developments that have taken place over a period of time. Nothing as such in international law, because judiciary itself is not important in international law. The most important thing in international law is UN Charter of 1945. That is the defining moment. The present structure of international law stands on that, because Security Council had the power to enforce international law. To what extent it has succeeded is a different matter. But United Nations is today the most important part of international law. Yes, madam.
The next question is, why has there been no intervention with respect to the treatment of Uyghur Muslims in China yet by any international bodies?
No international body has any right to interfere in the Chinese affairs. No international body has any right to interfere in Indian affairs. All that they can do is the Human Rights Commissioner, if any complaint comes, he will send it to this China, and China will respond. Beyond that, the Human Rights Commissioner can make his own inquiries, appoint an investigator, and obtain the information and report. But beyond publishing the studies and beyond trying to shame China or any nation, whichever has been guilty of violation of human rights, beyond shaming them in international public, you can't do much. If there is a substantive case, then one can take it to the international body, that is again Security Council. But Security Council again depends upon the functioning of 5 members who have the veto power. So nothing can be done under the present system with regard to whatever happens in whichever country, beyond creating some kind of a news in the news media. Right. Yes, madam.
So the next question is, how does the Hong Kong national security law violate the international law?
Yes, it does. It does violate. And these kind of security laws of various nations do violate human right. But again, nothing much can be done because there's no international human rights court to enforce and or correct these errors, these violations, or strike down these illegal laws. Nothing as such. Therefore, I said one of the requirement of rule of law is to create an international adjudicatory body or to vest the power in the International Court of Justice to entertain complaints, at least with regard to the violation of human rights by the nation states. Yeah.
Thank you, sir. So, one more question. How will President Biden impact international laws with relation to India?
Neither Biden could do anything, nor Trump can do anything, because India is a sovereign nation. They cannot really, the US cannot have impact over India beyond impact in certain investment matters. The other impact could be that if India enters into some kind of a security or military alliance with US, that is a separate matter, but that has huge implications. I don't think India would venture into that kind of an alliance with United States of America. Short, your point is whether Biden can make any difference. Biden cannot make any difference to India as such directly. Indirectly, he may have, his policies make some difference to India, particularly with regard to the trade policies, investment laws, or the regulation of social media. If the social media comes to be regulated by the US, not in India, but in the US itself, all these platforms of social media which we use, which everyone uses to transmit all kind of messages, which are some news, which news. If the platforms in United States of America are strictly regulated, perhaps it may have impact on India in a sense. It will have positive impact that we will get rid of a lot of fake news in India. Yeah.
Thank you, sir. I'd like to ask the audience once again if there are any more questions. Okay, presuming that there aren't any, I would like to thank you, sir, for addressing all of the questions and to the audience who have put forth these questions. I would now like to invite Geeta Shreya from 5th semester BA LLB to deliver the vote of thanks.
Good evening, all. I, Geeta Shreya, on behalf of our esteemed institution, would like to thank today's guest speaker, Mr. Mohan V., Senior Advocate of Supreme Court of India, for his wonderful talk. Sir, through your expertise, you have enlightened us about the rule of law and its relevancy in international law. Sir, through your talk, we are exposed to know about the subjects of international law like relation between sovereign states and environment, regulation of trade. You have also made us understand the concept of rule of law as the supremacy of law and the responsibility of international law and its intervention. Sir, thank you so much for such a delightful speech and for your patience for answering all our questions. And I also thank our respected Dean Sir, Dr. Subramanya, our beloved Vice Principal, Professor Praneshwaram, and faculties for their support and cooperation. And also, but not the least, I would like to thank my beloved friends for their participation. Once again, thank you all. Have a wonderful day.
Thank you.
Thank you.